Hello, everyone. Welcome to my case summary for the Supreme Court's decision in Guaranty Trust Co. versus York. This is a 1945 decision by Justice Frankfurter. It's 5-2, and it came several years after Erie. And it's important mostly for establishing the procedural law versus substantive law distinction. So plaintiffs brought a class action against Guaranty Trust alleging breach of trust, which is a state law claim, not federal. The case was heard in federal court under diversity jurisdiction, though. The defendant, Guaranty Trust, argues that the claim was time barred under New York's statute of limitations. The plaintiffs argue that federal courts should apply the more flexible rule of laches. This is a federal practice. The Second Circuit held that the federal court did not have to apply the state statute of limitations. So then this gets appealed to the Supreme Court. And what does the Supreme Court say? Well, we have to look here at whether when no recovery could be had in state court because the action is barred by the state statute of limitations, a federal court can hear the case because there is diversity of citizenship between the parties. So we have to decide if the state statute of limitations is substantive or procedural. If it's substantive, then the federal court would have to apply it under Erie. But if it's procedural, then the court doesn't have to apply it. So basically, they explain why it's okay to apply federal procedure. And this is a quote: "When a right is enforceable in a federal as well as in a state court, the forms and modes of enforcing the right may at times, naturally enough, vary because the two judicial systems are not identical." And that's, kind of a old school word for identical, I guess. But yeah, the gist of it is that procedural law is just about the manner and the form. They're not regulating anyone's substantive rights, so they're not granting you special rights or reducing your rights if you sue or are sued in a federal court as opposed to a state court. And then we get to the other question of why it's not okay and it's wrong to apply federal substantive law. And that's because litigants should not have different access to different substantive rights in federal court than they would in state court. And even though a limitations rule might seem to be procedural, the possibility of a recovery can depend on the limitation rules applied. So obviously, laches is different from New York's statute of limitations, and that's why one party wants one of them to apply and the other wants another one to apply. So, yeah, the question is whether such a statute concerns only the manner and the means by which a right to recover as recognized by the state is enforced, and if yes, it's procedural. Or the question is whether the statutory limitation is a matter of substance in that it significantly affects the results of litigation for a federal court to disregard a law of a state court that would be controlling in an action upon the same claim by the same parties in a state court. If yes, then it's substantive for purposes of Erie analysis. Okay, so as we know, as you'll learn, this case got modified in a sense. The Erie doctrine did by the later case of Hannah versus Plumer. I have that video up recently. It was 20 years later, and it kind of narrowed and clarified the outcome determinative test. But this case mostly should be understood for introducing the distinction between procedural law and substantive law. If you would like, you can check out my video on Erie Doctrine explained in 8 minutes, where I will explain how the cases of Erie, Guaranty Trust, and Hannah versus Plumer all kind of merge together to make the contemporary Erie Doctrine and how it's applied. But yeah, understand this case as mostly providing you with the explanations for the policies of state court, federal court, state procedural law, federal procedural law, state substantive law, and federal substantive law, and when the courts would apply those. So yeah, it's not that complicated yet, the Erie Doctrine. It gets more complicated once you get to Hannah v. Plumer. But yeah, I hope that you found this video helpful. I hope that you will use it to get an A+ in your civil procedure class, or if you're not a law student in law school, that you learned something interesting from this, or if you're an attorney, that you found this helpful, a helpful refresher of the case. As always, if you liked the video, if you found it helpful or insightful, leave a like, comment, or subscribe to the channel. I really do appreciate it. we're trying to grow this channel here. And yeah, thank you for watching, and I look forward to speaking to you in the next video.